appeal in the matter of Shyti and Secretary of State of the Home Department?
Yes.
My Lord, I appear with my learned junior, Mr. Mackenzie, for the appellant in this matter. My learned friend, Ms. Smythe, and Ms. Bahi appear for the Secretary of State in this matter.
Yes.
My Lord obviously is aware, I'm sure, of the fact that this is an appeal against a decision of the upper tribunal, which itself had allowed an appeal against a decision in the appellant's favour taken by the first-tier tribunal. What I propose to do, subject to anything the court may wish to raise, is deal with matters in this order. Firstly, deal with factual background, which I'm sure I can deal with fairly quickly. Then deal with the approach that the FTT is required to adopt following Begum. I think logic, I mean, that's the approach we adopted. Dealing with that first is the approach we adopted on our skeleton, and there is a sort of logic to it.
Can you help us to why that's an issue before us?
Well, it's an issue before you in the sense that it was raised by the respondent in their respondent's notice as another reason, effectively, for the upper tribunal, as I understand it, another reason for the upper tribunal to set aside the decision of the first-tier tribunal. Obviously, our argument here, we put our arguments in response. We, in particular, it seems to us that given the way in which the upper tribunal resolved matters, it doesn't actually...
I mean, you're challenging the upper tribunal's decision.
Yes.
And saying that they should not have interfered. Is it a he or a she?
A he.
He should not have interfered with the...
Sorry, so she sorry, when I said he, I thought you meant, for a moment, I've got the upper tribunal judge is a she.
She,
sorry.
okay.
Yeah.
And the first tier is a he.
Yeah. Yes.
That she should not have interfered with the first tier tribunal's decision.
Yes.
Surely that's the first issue. If you fail on that, there's no other issue. If you succeed on that, then we might have to then consider the respondent's notice. Is that right?
Well, my Lord, if we fail on that, so that the matter is remitted back to the first-tier tribunal, there is, in one sense, resolving the issue arguably is in fact more important in the sense that there is uncertainty as to the approach. The parties are here ready to argue that, and there is, in one sense, good reason for the court to resolve an issue that has been unresolved.
Well, except that might may arise more directly in the appeal we're hearing on Thursday.
My slight concern from that, in relation to that, as from the point of view of
because wouldn't it be overdue? There isn't yet a decision, obviously, because it was remitted for a rehearing, that you say raises the issue. Well, it's a theoretical issue as to how the first tier should approach it in the event of a dispute between the parties at the date of the rehearing, if that is what happens.
My Lord, one of the concerns I would have, to be completely frank about that, is if the matter were to be, if this matter were to be remitted, and obviously my argument is it shouldn't be.
I understand that, yeah.
But if this matter were to be remitted, it is quite clear, having had the opportunity to read the skeleton argument filed by the appellant on Thursday's case, that they are essentially piggybacking off the arguments in this case. It's unclear how, and I have to say we would be slightly concerned by effectively any rehearing then being bound by the outcome of Thursday's case in circumstances where Thursday appears to assume that the approach of the parties in Thursday appears to assume that the matter will be resolved in this case.
But in any event, hasn't the upper tribunal expressed a view in this case, in paragraph 16, 16 and 17, sorry, paragraph 16 really, where the upper tribunal judge deals with what should happen on remission. She says, following the decision in Begum, correct approach is in the first two paragraphs of the head note in, I don't know if it's pronounced Chicheri or something else. The upper tribunal has decided what approach should be adopted on the remission.
It has. We would obviously say that's wrong.
But you haven't.
Well, well, we had. I mean, whether we should have raised that in an appeal, the respondent's notice now raises that and puts it before the court.
Yeah.
And so there is a direction from the upper tribunal. I mean, whether or not, in one sense, that's directly challenged in any event, as we understand it, having looked at the produce quite a lot of upper tribunal authority, Chicheri represents the current state of the law, albeit the upper tribunal has recently revisited it in a case called Shimi, if I remember the name of the case correctly. But I mean, it basically, as far as we can see, it makes no material difference. It is the same approach as Chicheri. And that's, in one sense, why the issue is obviously potentially of importance, in the sense that from the appellant's point of view, obviously the appellant wins, that it all goes away. But if the appellant loses, and so the matter is remitted, the application of Begum may be of real importance to him.
There are two aspects of this. I mean, the first is in the first paragraph of the head notice quotation, paragraph 16, which is the approach to whether or not the fraud criterion's been established. Now, that question doesn't arise on these facts because, does it? Because your client has admitted that he lied.
Well,
not on one occasion, but on many occasions.
Well, the way we would analyse it, and the way we've sought to analyse it in our skeleton, is that the precedent fact, to use that language which appears in KV, is not simply that there is an untrue fact or a dishonest fact, or however you want to express it, depending on the content of fraudulent fact. It is whether that is material. And what is in issue in this case is, and was put squarely in issue with the appeal ground, is the extent to which the admitted untruth is material. And that links in, to some extent, with the Secretary of State's policy. Well, that really turns on two issues, or primarily on two issues. One is what the actual reasoning was for, in particular, the grant of indefinite leave to remain, and secondly, the Home Office's policy.
But that's unrealistic, because the decision was not based solely on the lies that were told in the application under the legacy policy. The decision relies on a number of different lies, and I must say provisionally, it doesn't seem to me right to say that one should just focus on a lie that was told in the application for ILR.
Well, except that's, in one sense, one of the things that arises from the policy, and in that the policy is that the policy makes it clear.
Sorry, can you go back? Just disrupt you, because you were seeking to raise the second issue, what I would call the Begum issue.
Yes.
What were the other issues that you were going to address and the order you were going to take them in?
After Begum, I was going to look at deal with the legal framework, which in one sense was the answer to my lady's question about materiality, because the policy documents we would submit are of real importance.
The legal framework to the
substantive decision.
Well, yes, but in particular relevant to your ground of appeal.
Yes.
Okay. Yes.
And then go on to the issue of whether the upper tribunal had grounds to intervene, which in one sense also raises which raises an additional issue, obviously, which is the extent to which the first-tier tribunal could be criticised for the approach it adopted, given what happened before the first-tier tribunal.
Right. So, two last. Can we do two last? I think might be helpful for us if you took the Begum issues I'm calling last,
Okay.
and dealt with the matter raised directly in your ground of appeal, and then we can see where we got to at the end of that.
I'm certainly happy to deal with it in that way, obviously.
Thank you.
Dealing with it in that way, I still need to, well, unsurprisingly, deal with the factual background.
Yeah, of course. Yeah.
The decision to deprive sets out the history of this matter and give references to some of the additional underlying documents. That decision to deprive is in the core bundle at page 92. And you will see in particular, well, firstly, just because it's relevant to the issues raised in the appeal, it's important to notice that the decision itself was taken under section 43, subsection 3. See that from the heading. More importantly, though, in terms of the factual background, there's no dispute that the asylum application, as set out in paragraph 8, was submitted in 1999 and claimed that the appellant had been born in Kosovo. That claim, effectively, which was a claim to Kosovan nationality, was then repeated in the asylum application. That's set out at paragraph 9. That asylum claim was refused, and this is recorded in paragraph 12, on the 9th of September 2004. The core bundle a little earlier on at page 84 has the refusal letter. That refusal letter essentially concludes, and one sees that from paragraph 9 at page 85, that there was no risk of persecution in light of the fact that it was said that there was now protection for ethnic Albanians. That's important because in one sense, it links to a point made by the first-tier tribunal about how any suggestion that effectively the claim to have been Kosovan impeded removal was speculative. ILR was then granted on the, and this, you see this going back to the decision letter, page 94, that was granted on the 2nd of July 2010. That's paragraph 13 of the decision letter. The actual grant of ILR, indefinite leave to remain, is at page 88. You will see from the first paragraph of that the reason given was length of residence. There's no reference there to nationality anywhere, as far as I'm aware, on the letter. That's consistent with, in the supplementary bundle, and this is referred to by the first-tier tribunal, in the supplementary bundle at page 44, you have the computer records from the Home Office's decision-making. Sorry, it's page 43 and 44. And you will, the conclusion reached, 43 to 44 seems to be sort of consideration of various factors. the final conclusion reached essentially was that at the bottom of the page, on the basis of length of residency and strength of connections with the United Kingdom, it's considered appropriate to grant ILR outside the rules. Yes, certainly. Malone and Friends just asked to draw attention to what was said at the bottom of page 43. Is the applicant of good character? Yes, is the answer given. Of course, as has been pointed out by the upper tribunal from memory, we'll come on to this, upper tribunal in other cases, this was an exercise being considered in the context of failed asylum seekers. That implies there will have been a number of people who've made claims that were rejected potentially as being false. That is reflected in our submission in the policy and is one of the reasons why rejected claims and claims based on false facts are not said to prevent someone getting ILR or indeed citizenship. Going back to the core bundle, paragraph 15 of the decision letter records how there was then in 2013 an application to naturalise, which again relied on Kosovo as being the place of birth, and it was on the basis of that application that nationality was granted. That's what, as I say, led to the decision that's being challenged. The key reasoning for deprivation is in the decision we would submit at paragraphs 16 onwards. 16 reveals, which is uncontested, the fact that the correct nationality is Albanian, not Kosovan. 17 records the fact that it had been argued by the appellant's representatives that nationality was irrelevant, essentially, or wasn't material. You see that about halfway down paragraph 17, where it said your legal representative state that you were granted indefinite leave to remain outside the immigration rules, and therefore it would not matter if you were a national of Kosovo or Albania. The argument essentially has been maintained. The answer to that is said to be, and I'll come on to why we submit it's not an adequate answer, but it seems to be at the heart of the Secretary of State's reasoning, is to say it's highly likely you would have been removed if the immigration caseworker was aware of the fact that you were Albanian. Unclear why that would be the case, given, as I say, that the asylum claim was refused on the basis that Kosovo was no longer an unsafe place. And that's said to mean that there wouldn't have been a grant of ILR, said you would not have met the requirements of indefinite leave to remain. And our submission is that the reasoning. What then follows is reference to two policy documents, and I'll take you both to both of those because they are material, and we would say that, that actually on a fair reading of the provisions, they actually support the appellant's case, not contrary to it. You then have paragraph 20, which is what...
Oh, wait a minute, please, Mr. Savvy.
Yes, certainly.
First of all, paragraph 18 says, the evidence shows you perpetrated material fraud, claiming you're a national Kosovo in order to acquire ILR status and citizenship. And there's a reference to Annex R. There's a reference to Section 9.1 of the Nationality Staff Instructions. Clear that you would have been refused British citizenship under S 9.5.1 and 9.5.2 had the nationality caseworker been aware that you presented a false place of birth to the Home Office and continue to do so throughout all his immigration history. The decision letter has already referred to 4 false declarations which the appellant made in the course of his immigration history. So isn't that an important part of the reasoning?
Well, what para 18 and 19 do in my submission, I'm not suggesting they're not important, is firstly they recognise the relevance of those instructions. I'll come on to what those instructions say. They're not suggesting that they're not following those instructions. And I'll come on to, as I say, I'll come on to those instructions, and in our submission they strongly support, in fact, the appellant's arguments. Secondly, what they don't clearly do, which is partly, which is significant as demonstrated by the instructions, is that they don't distinguish between the two decisions that needed to be taken. One was whether or not to grant ILR, and the other was whether or not to grant citizenship. And in our submission, and this is one of the reasons why the approach that was adopted in the first-tier tribunal was adopted, and I'll come on to that. If the Secretary of State is going to place separate reliance on the statements that are made for citizenship, what the Secretary of State has to say is essentially, even if you were entitled to indefinite leave to remain, and any misrepresentation was immaterial to indefinite leave to remain, I still would not have granted you citizenship because of the statements you made, and that is not what is being said here. There's a recording of the fact of previous statements, but it's put in the context essentially of paragraph 17 in particular.
Sorry, paragraph 18 says the evidence shows you perpetrated material fraud in order to acquire ILR status and citizenship. So it's applying it to both.
But the question that raises, and this is the point that really I'm making, is why was it material?
Right, okay.
And then you go back to paragraph 17 in my submission, and that's really the point I'm making.
Well, paragraph 17 is an answer to the representations that were made in response to the letter of 21st of November 2019.
But if para 17 is the only point at which there is I mean, the point that's being made in para 17 on behalf of the appellant was that the statements about Kosovo were not material. That's the only place at which that point is addressed, and that's the only place at which...
Yes, but the case that was being advanced was they weren't material to the grant of ILR under the legacy programme. That was the case that was being advanced in the representations, as I understand it, and that is the case that is being dealt with in paragraph 17.
But the reason why, and this is why, so one also needs to read it in light of the policy, the reason why that is so significant is that the policy itself makes the point, effectively, I'll come on to why I say that's the case, makes the point that ILR under the legacy programme effectively didn't depend on statements about nationality, and as a result, ILR was granted, or could be, as I say, any misstatements about country of origin were not material to ILR. And it then makes the point, goes on from that, to say if they weren't material to ILR, they weren't material to citizenship, effectively. And that's what the policy itself says.
If you look at, I mean, we'll look at the policy in a moment, but just,
yeah.
I mean, obviously one has to read the letter as a whole.
Yes.
And we stopped at 19, we need to look at 20. But if you look at 19, it says that the nationality staff instructions deal with deception and dishonesty. So we'll need to look at that when we come to the instructions.
Yes.
It's clear that you would have been refused British citizenship under S 9.51 had the caseworker been aware that you had presented a false case. So it is drawing attention to deception and dishonesty, isn't it?
It's drawing attention to deception and dishonesty, absolutely. But the question is, it's also recognising, certainly needs to recognise, it probably is recognising, that needs to be material.
Yes, but that is dealing with naturalisation.
Well, yes, because it's saying you wouldn't have been granted citizenship had the caseworker known that you'd made 4 false declarations in the course of your immigration history. That's effectively what paragraph 19 is saying. So of course it's material. It's saying the caseworker would have refused British citizenship.
But,
How's that not material?
well, can I take you to the policy? Because the policy is...
Can we look at 20 first, or look
Yeah.
at the rest of the letter first, then go and look at the policy? I think it
Okay.
will be more helpful if you don't mind.
Para 20 starts with the sentence, had the truth been known that you were truly an Albanian national, it's likely you would not have met the mandatory requirement to possess settled status. Question arises, why is that the case? That seems to, we would say, link back to paragraph 17.
Right.
Because it's talking about, para 17 is saying you wouldn't have got settled status because we would have removed you.
And then the next?
The next statement talks about maintaining the deception. What it's not doing in my submission is it's not performing the exercise. On the face of it, it links back to the prior sentence. It's not performing the exercise that we would submit it potentially needed to be conducted if there was freestanding reliance on...
But read, it says you persisted with the deception in your naturalisation application. So this is not dealing with the application bylaw, and tick the box to indicate you had not done anything to suggest you were not a good character, and used the same fabricated place of birth. Had you told the truth in your naturalisation application, highly likely you would have been refused citizenship on good character grounds. Therefore, the deception was material in that you would not have had settled status.
But the question still... I mean, all of that needs to be set against the policy, firstly. And the question is, why would you have been refused on good character grounds? The implication we would submit appears to be because you wouldn't have, had the truth been known, you wouldn't have obtained settled status, effectively. So this was material...
No, what's being said is you've made 4 false declarations in your immigration, as it was arguably being said. You've made 4 false declarations in the course of your immigration history, and you ticked the box saying you were a good character when you filled in the naturalisation application. Had the caseworker known about those 4 false declarations, something different would have happened.
Can I think it's important... Can I take you to the policies? Because I do...
Yes, of course. But I just want you to understand, Mr. Southey, why your current argument causes me some concern, because it doesn't seem to me to grapple with these paragraphs in the decision letter.
Well, in my submission, there's a limit to...
Your submission is that the... Should we look at the policy?
Yes.
And then come back to your
that may be the
submission?
sensible way of dealing with it. Thank you, my lord. If you go to... The policies are in the authorities bundle at... I'm taking it slightly out of order, but they are at... they're at tabs 46 and 47 of the authorities bundle, which start at page 1130. Just to put these in context.
I think we're all on paper. My tab 46 starts with page 1125.
1125, yes, sorry.
Okay.
Sorry, if I got the page wrong. I think the 40, just to put them in context, 46, as I understand it, is the policy specifically dealing with deprivation. 47, which we'll come to, which is also relevant, is the policy dealing with good character for the purposes of citizenship applications.
Just in case it assists, their annexes R and S referred to in the decision letter.
So 46 is R.
Yes.
Thank you. 47 is Annex S. Thank you.
Yes.
Yes.
46, page 1130, deals with the issue of materiality.
Sorry, which paragraph are you taking us to?
It's the section 55.7, but in particular, what I draw attention to is para 55.72, third bullet point, and 55.74. They, in our submission, need to be read together. Okay.
Well, don't we need to start with 55.7.1?
Well,
that sets the scene for...
That's what my learned friend just asked me to draw attention to.
Yes.
It does set the scene. What I was, I suppose, really trying to focus on is what is said more specifically about false details in relation to applications.
So, if the relevant facts, if they've been known at the time the application was being considered, would have affected the decision, blah, 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 should consider deprivation. This will include, but is not limited to.
Yes.
Yeah.
Key point we take from this, but it needs to be read, obviously, with the policy that actually applies to good character at the time of citizenship applications, which is what I'm going to come on to, is that the two passages I've drawn attention to clearly draw a distinction between false details that lead to status being granted and false details that may be irrelevant. And in particular, it makes the point that concessions, and we're talking here about effectively, concessions may mean that a lie is irrelevant.
Sorry, say it again.
55.74 makes the point that, in particular, concessions may make a lie irrelevant. Now, how that applies in practice it is clearer, we would submit, from the next policy, which if I can take you to.
All that's really saying is that, I mean, in a sense it might be obvious. You've got to look at whether or not the relevant facts would have affected the decision. Because if the relevant facts wouldn't have affected the decision, then they're, putting it in a circular way, they're not relevant facts.
No, but that's one of the reasons.
So it's materiality, and that's.
But that's one of the reasons why I'm saying that the next policy is potentially more important, because it's more specific about what is material. If you then go to paragraph 47, tab 47,
Yes.
page 1165, to say this is the guidance that is given to caseworkers considering citizenship.
On which page?
1165.
Thank you.
And you, just to put it in context, para 9.1 is a general statement about lack of frankness, but it needs to be read, obviously, with para 9.51, which is specifically concerned with, again, although it's not headed materiality, it is clearly concerned with materiality. And you see that, and it's not just about materiality in the immigration process, it's materiality in the citizenship process. One sees that from paragraph 9.51.
Yes.
And it requires it to be directly material to the acquisition. Now, how that is then applied in this context, and this is the most important bit in our submission, is clear from contrasting examples A and B below. And I'd ask you to consider A and B.
Yes.
Now, on the face of it, we would submit this case is effectively case B. It's someone who, as in case A, applied for refugee status on the basis of being Kosovan when he in fact was Albanian, but didn't get ILR because of his refugee claim. He got it from a policy where, on the face of the decision is based on long residence rather than any other basis.
Well, C is Mr. C entered the UK in a false name, previously been removed, and applying for a citizenship, he now admitted his true identity. If the fraud was material to the good character requirement, we should refuse the application and impose a 10-year ban. So that's another example of materiality.
But it's another example, but it's a different. I mean, it is significantly different to the circumstances of this case and example B. B, on the face of it, is precisely how describes pretty closely what happened in this case. It deals with a situation where the ILR is granted for reasons unrelated to the refugee claim. And it specifically then deals with the relation with the significance of nationality in that context, in the context of then subsequently applying for citizenship. And on the face of it, the logic of example B applies in this case. It is a situation where the grant was not based on nationality, and so then nationality becomes irrelevant for the citizenship purposes.
May I just ask one question on A and B?
Yes.
In B is where there are family concessions and you've got family members which are wholly unrelated to your nationality. But in example A, at the end of the first paragraph, it specifically says the individual was in fact Albanian, was therefore not at risk on return to Kosovo, as he would in fact have been removed to Albania if his true nationality had been known. And that would have prevented you from getting the concession on which you did rely, which was 10 years effectively.
But the difference between that case, between example A and this case, is that in example A, the reason he can't be removed is that he gets refugee status. So there is a legal bar because he's got refugee status based on his false Kosovan claimed nationality to him being removed. So that's why it's being said he would have been removed, because effectively the refugee status is the block. Here, the refugee claim is refused, which is the situation potentially in B. His refugee claim is refused, so there's no legal bar to him being removed. The Secretary of State's case is it's safe for him following removal. He just doesn't get removed. Presumably because of the inefficiencies of the asylum system. Lord, so on the face of it, certainly as a matter of law, that the claim that is made is not, unlike example A, that prevents his removal. So.
These examples are all examples of cases where deception's been used in a previous application, and either the deception's been identified and not relied on by UKBA, or was factually material to the grant of leave. And it's dealing with that and saying that caseworkers should not use that deception as a reason by itself to refuse the application under 9.51. I'm not sure on these facts how far these examples take you, even if your case is precisely analogous.
Well, except what they are, these examples are being used these examples are being used to guide caseworkers as to whether or not someone should be granted citizenship. So what example B is essentially saying is that, and it uses the words irrelevant, is if you're in the category of someone in B who it's discovered during the process has used a false nationality, but because of the basis on which they were granted ILR, that didn't cause them to be granted ILR, then there's no reason why naturalisation shouldn't proceed. That's what example B is. That's why example B exists. It's not saying essentially in example B, refuse citizenship, but refuse citizenship for different reasons. It's expressly saying essentially you during
no,
that.
It's saying that it's open to you to refuse citizenship for different reasons. It's not saying you can't refuse citizenship.
Well, obviously, I mean, there may be all sorts of reasons why someone is refused citizenship, but what it's saying is that the issues of nationality are irrelevant to your decision making regarding citizenship. And that's what it's, in my submission, that's what the last sentence in particular is making clear, and that's what it's...
What it's saying is issues of nationality are irrelevant to the citizenship application. That's your submission.
Yes.
All right.
Does it say persistent fraud that feeds into the citizenship application is irrelevant?
Well, it doesn't use...
I thought you were taking us to this, to support your submission, that the refusal letter or decision letter is narrow.
I am, but...
And doesn't raise, only raises one issue, namely that the reliance on nationality was only relevant to the ILR.
Well, can I...
Does this why on the basis of these instructions is the scope of the decision letter limited?
Can I just preface what I'm about to say by one thing, because
yes.
It's just given the way in which my lord had asked the question, and it's perhaps something I should have said earlier. In terms of the decision letter, there are possibly two ways of reading it. One of which, just to be clear, is the way in which I'm arguing for. Alternatively, if there's doubt in the decision letter, at the very least, that justifies the approach adopted by the first-tier tribunal judge, which was to ask for assistance and then not get it. And so, that was something I was going to come to, but it's an important part of the context, because obviously
There's no suggestion anywhere that the decision letter is ambiguous. There's just been a relentless focus on one aspect of it.
Well, I'm not sure that that's entirely... I'll come on to why I say that there was a suggestion that it was ambiguous that may have prompted the approach of the first-tier tribunal judge. But can I come back to the second question, the substance of the question my lord asked
yes.
me a moment ago? The passage I've just taken you to of the Home Office policy, I accept, does not use the language I think my lord used of repeated fraud.
I put it in quite an extreme form.
Yeah, absolutely.
To test your submission.
But my lord, what it does, I mean, if you look at what it's describing in terms of Mr. A and Mr. B, Mr. A and Mr. B are both people who, on the scenario described, make a false claim with the deliberate intent of achieving refugee status that they're not entitled to. In one case, that's a successful process because they get refugee status. In B, it's not directly successful because they don't get refugee status, but the period of time or whatever they've been in the United Kingdom ultimately results in them getting status. Example B then goes on to look at in the sort of, I suppose it's the third and fourth sentence, what happens if essentially the citizenship claim is maintained during the application for British citizenship, because that's why it's looking at the relevance essentially of true nationality during the British citizenship application. So in my submission, the language used isn't the language obviously of my law, but implicit in that is a situation, it's expressly addressing the situation where someone does what this applicant does, which is that they use a false nationality during the asylum process and then repeat that during the Nationality Act.
So we go back to 9.51,
yes,
which sets out the policy where there is evidence to suggest that an applicant has employed fraud during the citizenship application process, and the fraud was directly material to the acquisition of citizenship, caseworkers should refuse the application.
Yes.
So that's the fraud can cover anything that's materially relevant to the application.
Well, the language used is which may make a difference, is directly material to the acquisition of the or to the application.
Yes.
Directly material.
Yes.
And what the examples are clearly intended to do is give guidance, because they're all examples where there is fraud, but they're intended to give guidance as to what's directly material and what's not directly material.
And good character is directly material.
Good character is directly material, but example B suggests that the way in which this is being approached by the Home Office, or the way it was approached by the Home Office at the material time, was that an irrelevant statement as to nationality, an irrelevant false statement as to nationality, didn't result in an issue of good character, because that you see that from, in particular, the second last sentence in example B, where it says it would therefore be perverse to assert that a previously disregarded fact could be regarded relevant at a later date to a consideration of good character.
But does that deal with the second? That's a one-off use of a false application for asylum, whereas here we have an application for citizenship which engaged the same lie later on.
Well, the reason, in my submission,
But, Mr. Southey, aren't there two separate things going on? One is the good character requirement, and the second is what this is dealing with, which is the relevance of evidence of fraud in the immigration and nationality process.
well, there are, in principle, two issues, good character and the relevance of fraud. But that's why I drew attention in particular to the second last sentence within example B, which does specifically deal in this context of fraud with its relevance to good character.
As my Lord has said, that could be relevant at a later date. So what it's doing is looking back, and is it dealing with the repeat, repetition of the same false fact?
Well, my Lord, in my submission, it is dealing with the repetition, and the reason why it's clear, there are a couple of reasons why it's clear it's dealing with the repetition. I mean, to put what I'm about to say in context, it clearly has, because this is before the grant of citizenship, it clearly has to, even on my case, and I accept this, be dealing with the situation where it's become clear during the citizenship process that a false claim was made. Whether that's because of checks or because of some other route,
yes,
it's not addressed. But I have to accept, because this is the pre-decision,
yes,
it's dealing with a situation. But I do submit that it's dealing with it covers the situation, which is where there would be a multiple application. It covers the situation where an individual makes the application for citizenship on the basis of the false nationality, and that is uncovered before the decision. And the reason I say it covers that situation, which in my submission is effectively the point that was being put to me by Lord Justice Dingemans, is this. Firstly, because the whole of this section, para 9.5, is said to apply to fraud not just during the immigration application process, but during the citizenship application. One sees that at para 9.51. Secondly, but more importantly in one sense, if you look at what is said in relation to example B in my submission, what example B is doing as it sort of goes through the paragraph is it's sort of moving away from the impact of the false nationality on ILR, and it's focusing on false nationality in the context of citizenship, and is making the point effectively that
well, you rely on the second to last sentence. It would therefore be perverse to assert that previously disregarded fact could be relevant at a later date to a consideration of the character.
Exactly.
That's your point.
Exactly.
Yeah, I've got it.
So that's what we said about policy, and if you then go back to the letter, and obviously, as I say, the letter refers to specifically this policy in paragraph 19.
Yes.
The point I was making before was when you read this letter in light of that, the question in our submission that then arises is, given what is said in particular in relation to example B, the question then arises, well, why is this material? And that in some respects reflects the point that was raised on behalf of the appellant at para 17. And reading through the letter, when you get to materiality, para 17 is really the high point of the Secretary of State's case about materiality.
Thank you.
In light of the policy. And that's why in my submission, the policy, one did need to read the two together. Now, what then happens sort of after the decision is that just to put in context, because ultimately, obviously, the focus is on whether the first-tier tribunal erred in law, because that's what the upper tribunal had to consider. The appeal ground is lodged, the appeal notice is lodged, which specifically argues that there was that the false material wasn't material, page 62. A skeleton argument is lodged, and this is in the supplementary bundle, page 38. Which raises, well, page 35 actually may be a sensible point to
Sorry,
start.
say it again.
Page 35
Right.
is because that's where the upper tribunal judgment in Sleeman is raised, which at the time, well, and still is, we would say, a governing authority, but certainly at the time it was the only authority relevant either parties identified. The authorities my learned friends identified were later. And what essentially is said is that this case is indistinguishable from Sleeman. But more importantly, in one sense, it goes back to the point I made about sort of the position not necessarily being clear. Paragraph 15 also raised a specific issue as to whether a separate argument was being raised about citizenship. If you then go back to the core bundle, the way...
Then if you look at 16, you say, not you, but it's your junior, isn't it?
Yes.
Does wish additionally to answer argument that your client should be deprived because he maintained his false. That in fact takes the note. So it's put in the alternative.
Yes. But the response... I have to say, I wasn't completely clear on this, but the way in which first-tier tribunal procedure now operates in immigration is that the skeleton is filed early on, and the Home Office then conduct a review.
Yes.
And you see the review document going back to the core bundle at page 100.
Yes.
You see there effectively an identification of the issues, but there's no engagement essentially with the point that was being made in the skeleton about the...
Well, but paragraph 1 said... Sorry.
No, sorry. But yes, as my lady was saying, paragraph 1 rely on the reasons for the refusal. So the letter is maintained.
The letter's maintained. I'm not saying the letter's not maintained,
No.
but the point obviously that was being made in the skeleton was this is what we understand the letter to mean. Tell us if we're wrong.
I understand.
Yeah.
You did put it in the alternative, but say in paragraphs 15 and 16. A 2.1 was the citizenship obtained by means of fraud, in the sense this conduct was directly material to the decision to grant citizenship. And that's the right, you would say, question or issue.
Yes.
So it's right legal issue, you might say.
Yes.
So the question is what factors, matters were relied upon in support of the legal issue under 2.1.
Absolutely.
And those were the matters set out in the refusal letter.
But obviously then what the appellant was saying through counsel was, we understand your letter as saying that what is material was the impact effectively of the falsity on the grant of ILR.
Well, except if you look at paragraph 1 on page 101, the first substantive paragraph, it submitted the appellant had every opportunity to inform the Home Office of his true nationality at 3 key stages: asylum application, application on the legacy programme, and the application for British citizenship carried on with the deception. So it's identified all those stages, including in particular purposes of this appeal, the application for citizenship.
But
It goes on to say, sorry to interrupt,
Sorry.
in the next paragraph, 3 lines down, the respondent would respectfully cross-examining the appellant on evidence in respect of these matters and those raised within the refusal notice.
well, that seems to be a reference to, because it's following on from the offending behaviour, which would potentially be relevant to the exercise of discretion. So that the first 2 sentences above that are all to do with the...
Yes, but it says, in respect of these matters and those raised in the refusal notice. The refusal notice doesn't refer to his offending other than in passing, as I recall.
But the fundamental point I would make about that, about at the risk of repeating myself, is that what was being said by the appellant was not that he hadn't made false statements, that was not in dispute. It was what was being said was this isn't material, and in particular, and that raised the question of how materiality was being particularly in light of the policy, how materiality was being put by the Secretary of State. And we would submit, particularly in light of the policy, that the natural reading essentially was that there was this sort of follow through from ILR, and that was the question that was being raised. But in one sense, again, all of this is the context. I mean, the real issue here is obviously the approach of the first-tier tribunal judge. And the first-tier tribunal judge, his approach is essentially at...
Sorry, just before we get to that, and before we leave 100,
Yes.
can I just ask you at the bottom of 100, there's reference to the witness statement by your client, where the respondent says, and this may or may not be a fair characterisation, he accepts his actions were significant and material to achieve a fraudulent outcome. Do we have the witness statement?
I don't think we do. I don't think we do.
Okay.
We can... Yes.
Sorry, I interrupted.
Could it be got for us?
I can't imagine why it can't be got.
I couldn't find it. But,
Yeah.
No, I couldn't find it either.
Thank you. Sorry, I interrupted you.
No.
Take us to the FTT.
Yeah. So we get to the FTT, and unsurprisingly, in light of, and I took you to the reference in the skeleton to Sleeman, and what the appellant was saying about how his case was indistinguishable from that in Sleeman.
Yes.
What is clear in our submission is perfectly legitimately the first-tier tribunal judge is asking, what is it? Is asking the Home Office essentially for assistance as to what it is that distinguishes the case from Sleeman. And come on to Sleeman in a minute. And Sleeman is, we would submit very closely, is very similar to the facts of this case. Very similar to the facts of this case. And what in our submission the first-tier tribunal judge is entitled to do is, given the history and the points I've made, is entitled to seek assistance from the Home Office as to what their case is, and in particular how they are distinguishing the case from Sleeman.
Can I just ask what happened at the first-tier tribunal? Because you've very kindly shown us the Secretary of State's response, which said, and I'm going to cross-examine you on all these things.
Yes.
And then if we look at paragraph 9, it says it was listed for hearing submissions only. What happened there? It may be your junior.
Yeah, it may well be that.
Sorry.
He wasn't called. I think that's.
I know it was all at CVP and it's a difficult time for everyone. So I mean that may explain part of what happened. But it says it's listed for submissions only. It just wasn't called. I mean I appreciate he obviously wasn't called.
So that suggests there'd been an intervening case management decision. Had there?
Probably, but we'd need to check, as the answer I'm getting, but probably we'd need to check that if it was listed for that basis. We have the statement. Would it help if we emailed now to clerks?
Yes.
Yeah,
please.
We can do that. We certainly, thank you.
Yes.
I mean, one thing obviously that is striking, in any event, which may well explain the approach that was adopted to the evidence, is that neither party effectively appears to be challenging the facts that the question, as I say, that was being raised was whether the case could be distinguished from Sleeman. The judge was seeking assistance in our submission with that fact, with that issue. I don't think there's any dispute that he got very limited assistance. But in particular, what he didn't get was any argument, it would appear, suggesting that what the Secretary of State was seeking to do was raise an issue not raised in Sleeman, which was the specific issue of the impact of the false statements on citizenship, essentially. The distinctions that were drawn, apparently particularly in paragraph 17, points that were made in paragraph 17 weren't, and nobody suggested this is wrong, weren't matters that the judge concluded were material distinctions.
Now, the FTT does not record a concession from the presenting officer that, apart from the Sleeman point, everything in the decision letter was being abandoned. Is it any part of your case that there was such a concession?
No, we've not argued.
No, I just wanted to be clear.
Yeah.
Okay, so no concession by presenting officer.
I mean, what the judge does do, in our submission, which indicates that he was adopting, in our submission, a proper approach effectively to this, is if one looks at paragraph 21 and 22, he effectively raises the issue of the fact that, unlike Sleeman, there was no specific statement in the decision that nationality was irrelevant. So he's not in our submission simply sort of basing his decision on the failure of the failures of the Home Office presenting officer. He is going beyond that and engaging more substantively with the issues.
Sorry, where just show me that again.
It's really the last two sentences on paragraph 21 and then para 22. What?
I don't really understand that sentence. Arguably, that is one step further than the instant appeal, as nationality is not specifically stated to be irrelevant.
Well, I think what he means by that is, or what I submit he means by that, is that in Sleeman, because you'd had in the decision letter an express statement that nationality was irrelevant, you might be able to say that the case about materiality in Sleeman was stronger than that in the appellant's case.
I see.
And I think what I would submit he's doing is he's not having had a huge amount of assistance. He is looking for reasons to distinguish Sleeman and identifying, if you like, one that he thinks might have been raised, wasn't in fact raised, but concluding in para 22 it would have made no difference, that distinction. That's why I'm saying what he's seeking to do is go beyond simply the sort of inadequate assistance he's got from the Home Office.
But it's all circling round the question of whether Sleeman should be followed or can be distinguished. It doesn't grapple with other material in the decision letter.
It doesn't grapple with other material in the decision letter, but equally, two points about that. Firstly, the point that was effectively being made was by the appellant was, look at Sleeman. Sleeman is factually similar. That shows what is material and what isn't material. and secondly, I mean, and that, once that's raised, it would have been open. In fact, arguably, this is what the Home Office should have done if this was their case, for the Home Office to say, well, this is different to Sleeman because we believe that unlike in Sleeman, there is a freestanding point about the impact of the false nationality on the grant of citizenship.
Well,
Right.
it's not so much the false nationality, it's the fact that he's lied. It's a slightly different point.
Well, yes. I mean, yes. I mean, I was using the false nationality as a shorthand for that point, but yes.
So is that it on the first year?
Yes, I think that's it on the first year tribunal. Obviously the Secretary of State appealed, raising and the appeal grounds are in the core bundle at page 47, or the material bit of the appeal grounds is at page 47. And the ground, as I understand it, effectively is allowed is just by the second hole punch on page 47. The grounds, which may be relevant to some of the issues the court raised with me first.
Well, is that right? I mean, the first year tribunal granted permission to appeal, and as I understand it, didn't expressly limit the grant. And I thought the way one construed grants of permission to appeal to the upper tribunal was that unless the decision maker expressly says that permission is refused on something or other, then the grant is to be construed as a grant of permission or grounds. Have I got that wrong?
No, but what I said was that this was the ground that was allowed. Is that I think not that when I meant allowed, it was the one that was ultimately successful. If you look at go to page 37, which is the upper tribunal decision on error of law.
I'm so sorry, I misunderstood you. I thought you were talking about the ground of appeal for which permission was given.
No.
I'm sorry, it's my fault. I misunderstood you.
No.
Right. Okay. Well, forget I spoke then.
No. May be relevant just in passing part if we come back to the first issue that I raised about Begum. Those grounds of appeal said nothing about Begum. Begum was raised initially by the appellant in his Rule 24 response, which is in the supplementary bundle at page 24. I'm told that at the grounds of appeal, Begum hadn't been decided, and that maybe, but that wasn't meant.
That would explain it.
Well, except it wasn't meant as a. I'm just, in one sense, just talking about what was before, because the point I was going to draw attention to, which is the critical point, really, in one sense, is if you then go back to the upper tribunal at paragraph 11, which is the more significant point, is that having had it raised in the Rule 24,
Yeah.
the Secretary of State was invited essentially to consider whether to amend the grounds, and in light of Begum, and declined to amend the grounds.
Okay.
That was the more important. That was the point that was really.
But did it? I mean, does that matter if Begum ground was before the upper tribunal by virtue of the Rule 24? No.
Well, in one sense, it wasn't, in the sense that we would submit it wasn't, in one sense, before the upper tribunal, in the sense that the Rule 24, if you go to the Rule 24,
Yeah.
supplementary bundle, page 24. Actually, page 30 is the relevant passage. Paragraph 23.
Yeah.
Essentially, Begum was identified, but it was said not material.
Right.
So, neither, by implication, because the Secretary of State wasn't seeking to amend her grounds, by implication, I suppose neither party was saying this is material.
Right. Okay. That's helpful.
I mean, yeah.
I mean, it might not be material to the grounds of appeal, but it was going to be potentially material to the terms of the remission, isn't it?
Yes.
Could I just invite you
Yeah.
just to read on to paragraph 11, which says Mr. Clark saw no need to apply to amend the grounds appeal because he felt that he could address the existing grounds in light of Begum. And he had actually sent Begum to the tribunal the night before by email. So that's paragraph 11.
Oh, I see. Okay.
Sorry to interrupt, Mr.
No, sorry. The point I was making, I mean, it's difficult to say. I mean, to slightly expand on why I was saying that by implication it was being said in one sense it was irrelevant, was that either I mean, the issue that was being raised was the failure to consider or the relevant issue that was being considered, because it's the one that led to the appeal being allowed, was whether the Secretary of State, whether the immigration judge had properly considered the refusal letter. Had there been a freestanding criticism, essentially, of the approach of the first-tier tribunal judge in light of Begum, that would have, and this is the point I was perhaps making badly, that would potentially have, well, no, that would have required a ground of appeal to be lodged, and nobody was putting in a ground of appeal, was my point.
But Begum didn't really arise on the findings of the FTT, because the FTT, there was no dispute of fact, and the FTT simply held, as a matter of law, fines Lehman, Secretary of State, the fraud wasn't material, and therefore the Secretary of State should not have deprived.
Well, Begum, I mean, obviously our case is that Begum doesn't make a difference, but trying to be as fair as I can, one could see a situation where the Secretary of State was arguing, essentially, it's not for you to decide, first-tier tribunal, whether or not this admitted falsity was material. My refusal letter asserts it is material. You can only intervene on public law grounds.
Oh, I see what you mean.
Yeah.
Yeah, no, I
That-
follow that. Yeah, okay. Yeah,
So, I mean,
I was being a bit slow about that. Thank
No,
you.
no.
All right.
Yes.
Obviously, the appeal is allowed, and the upper tribunal's reasoning is at key reasoning is at page 37. And effectively, the reasoning at para 14 and 15 is that the Secretary of State had adequately identified reliance on fraud through the citizenship application, had identified that sufficiently clearly that the judge needed to engage with that.
Yes.
Now,
That's also dealt with in paragraph 7.
yes.
So in other words, it was decided that the first-tier tribunal judge had failed adequately to, as it said, deal with the points raised
In the refusal letter.
in the refusal letter,
Yes.
which were all reliant on.
Yes. Well, which according to the first upper tribunal, rather needed to be engaged with expressly.
Yes.
It's perhaps an alternative way of putting
Yes,
it. But,
probably a better way. Sure, it's a better way.
can I then? So that's the context. I mean, that's the factual context. Turning then to the issues that were before the first tier tribunal, I'd drawn attention to obviously the Home Office policy, but
Can you just sort of, in summary, help us as to why do you say that decision, why the upper tribunal's decision, putting it bluntly, was wrong? What was the error?
because the approach of the first tier tribunal, which was to effectively rely on the way in which the case was and wasn't being put by the presenting officer, was a perfectly proper way for the first tier tribunal judge to approach the matter. The first tier tribunal judge was not obliged to deal with each and everything raised in the refusal letter. We would submit this clear case of Court of Appeal authority to that effect. Instead, the first tier tribunal judge was entitled to look at a decision of the upper tribunal, the only one that either party had identified on point, and still at that there are, Millennium Frame relies on more more recent decisions, but at the time of the decision that was still nobody's identified any other upper tribunal decisions on point, and seek assistance with really whether there was any proper basis for distinguishing it.
Thank you.
It seems from what the FTT record of the presenting officer's contribution to the proceedings that, for whatever reason, the presenting officer doesn't seem to have prepared the case at all and appears to have extemporised some arguments on the hoof in order to distinguish Sleeman. In that situation, does the tribunal have no duty to consider the terms of the decision letter? Because I mean, normally when one sees an FTT decision, it starts with the decision letter and summarises what's said in the decision letter, and there's no reference other than in passing to the decision letter in this decision.
A couple of things. Firstly,
Yeah.
just in terms of sort of like the premise on which the question is asked, can I just put add one thing into the equation, which may be relevant, which is obviously the actually two things that may be relevant.
Yeah.
The first is that the immigration judge didn't just sort of say to the Home Office presenting officer, "You're clearly poorly prepared, that's tough." The Home Office presenting officer was given an opportunity to
read Slim.
to read Slim and to sort of fill in the gaps in his preparation, and that's an important aspect of it because it means that there was an attempt by the first tier tribunal judge, arguably, to go beyond what fairness required in the circumstances, but certainly to ensure that he properly understood what the Home Office's case was, despite the failings of the presenting officer. Second, other point I would put about that may be relevant to what was required on the circumstances of this case goes to the sort of potential significance of Sleeman. He, in my submission, and this is why I was going to go to Sleeman, was entitled to say, actually, this looks on all fours with this case. Why am I not entitled, effectively, why am I not entitled to rely on Sleeman? And that, I mean, if you think about this in one sense as a reasons challenge, reasons need to deal with primary to deal with the key issues, effectively, slightly paraphrasing, or the key issues dispute. I'm trying to remember the exact phrase, and I'm having a
Well, this isn't a reasons challenge, is it? Anyway, don't just ignore that intervention. Yeah, so go on.
Well, there's quite often in my submission there's an overlap between reasons and substance, in the sense that the Home Office is saying here, effectively, the first tier tribunal judge didn't demonstrate they'd addressed this, and the reality is that there may have been two things that happened. One, the immigration judge thought about the issue and didn't resolve it in favour of the, or alternatively, the immigration judge just didn't address the issue. But that's why there's an overlap in my submission with reasons. But in those circumstances, what the immigration judge was entitled to do was adopt the focus he did, which was to say, essentially, on the face of it, this case seems similar to, or indistinguishable, perhaps more importantly, from Sleeman. Tell me what the issue is.
Right.
I mean, there are cases, I don't know whether they still happen. I mean, one used to see cases in which the Home Office weren't represented at all in the FTT. And in that situation, the FTT doesn't just roll over and allow the appeal. It considers the decision letter and the arguments for and against it.
But in circumstances where the Home Office is represented, and obviously that's desired, then in my submission, a judge is entitled to, which is what we submit is clear from case law of this court, that the first tier tribunal judge must be entitled to rely to some extent on the representation of the Home Office.
All right, well, I think we'd be quite interested to look at these authorities that you have alluded to.
I think it's an authority, to be clear. Just
Yes.
yeah.
All right.
Just going back, I think you were asked yesterday that in paragraph 11, it was said that both of the upper tribunal decision, both representatives made submissions depending on their written arguments. The only written arguments on behalf of the Secretary of State were in the appeal document.
That's as we understand it.
Right.
Yes, there were a series of emails from both parties trying to get to the bottom of that. But
can you just help me? Can you remind me where the written submissions were on behalf of your client for the upper tribunal?
The upper tribunal, in terms of the upper tribunal,
Yes.
there was the. I can never remember the name of the rule. The rule 24, I think it is, submission, which is at page 24.
Which we've looked at.
We've looked at, yes.
And that was it.
That was it, yes.
Thank you.
I've just been handed, I haven't had an opportunity to look at them, hard copies of the statement of the appellant.
And not just to try and understand the scope of the debate before the upper tribunal. Thank you very much.
Yeah.
The point you just made is that I mean, this is putting it very loosely. It was sort of almost too late for the Secretary of State to raise this argument. It wasn't placed squarely in oral argument before the first-tier tribunal, and the first-tier tribunal judge was entitled to rely on the way in which the case was put by the presenting officer.
Yes.
Can you help me as to how that formulation finds expression in the Rule 24 response?
The Rule 24 response, just to put in,
Because this was the written argument before the upper tribunal.
I think the Rule 24 response has I'm trying to remember what the rule says, has a specific purpose. So it's not the equivalent of a skeleton argument, I don't think. So
that point is not made in the written document.
I don't think it is from memory, but
it was made in the oral argument? Because I'm not sure I see it in the decision. In other words, I'm just trying to find out the points that were advanced before the upper tribunal. Just can I just be clear about the Rule 24 response? Although the Rule 24 response has a specific purpose under the rules, yes.
If you go to paragraph 15, 16 and 17
yes.
of the Rule 24 response, that is...
okay, that's where...
Yeah. That's essentially the point I think I'm making at the moment. It's essentially saying we are relying on the limited assistance that was given by the Home Office. And 19, Moylan Jr. has pointed out.
Yes, 19. Thank you. So the point was argued before the upper tribunal that effectively it was too late.
Yes. Yes.
Thank you. Yes.
Now, to put the reasoning, as I say, of the first-tier tribunal in context, if you go to the authorities bundle tab 17, you will see that the background to Schliemann is described at paragraphs 1 and 2. In particular, that was a case where
Yes.
ILR was granted on the basis of the length of time that the application had been outstanding. That was granted in 2010. That was followed by a grant of citizenship. There isn't, it's fair to say, and I was just thinking about this again, I don't think there's any express reference to a fraudulent statement in the citizenship application, but given it doesn't come to light until 2015, or 2013 rather, when there's an arrest in relation to money laundering, the reasonable assumption must be that the citizenship was essentially maintained, or the false citizenship was maintained during the citizenship application.
That's quite a leap to make.
Well,
I mean, it might be right. I mean, a better view may be that the Home Office didn't wake up to the point that there were serial frauds in that case.
It's consistent also, if you look at paragraph 15 of the judgment, the first tier tribunal whose judgment was set aside regarded it as significant that there'd been no steps to correct. So unless somehow the requirement for citizenship on the form had been left blank, the implication must be that if he hadn't corrected it, he presumably was putting in the false application citizenship. The decision letter is also consistent with what I've just said, in the sense that you see at the decision letter, paragraph 42 of the Upper Tribunal's judgment, paras 20 and 21 in particular, references essentially to reasoning very similar, we would submit, to the reasoning in this case.
Well, that's one of the issues, isn't it?
Well,
because this is focusing on the ILR, well, the previous, but particularly the...
Well, not necessarily. Paragraph 21 goes on, this is perhaps the point I was making about the letter in this decision, about the extent to which it is clearly distinguished. Because in paragraph 21, you've got the reference to British citizenship.
I know, but it's saying this deception. The deception was, the crux of the deprivation in paragraph 20 is that had you not deceived the Home Office, you would have been returned to Lebanon. And then wouldn't have been in, etc. So that it's made clear there what the crux of the deprivation argument is. And with respect to your arguments, it's a very differently formulated decision letter from the one we have.
Well, it's...
But unlike this case, I mean, we know what is in the decision letter in this case. The decision letter is hardly referred to at all in this decision of the Upper Tribunal. There's an allusion to it in paragraph 3, another reference in paragraph 11, but we don't see set out exactly what was said in the decision letter, other than the short references, or have I missed something?
Yes, sorry, if you're talking about the Upper Tribunal in Schliemann, it's paragraph 42. Sorry, I...
Right. Okay, right.
Sorry, that's what I was...
I'm so sorry, that's mine.
No.
And when I was saying that it's differently formulated, you would say, your submission is that they are sufficiently similar, or...
They're sufficiently similar to allow the judge to, the first tier tribunal judge, to raised the issue he was raising, which is, can you distinguish them? And the reason I say they're sufficiently similar is because going back to para 21 from within the letter, it does, it's fair to say, refer to this deception, but the deception is making yourself appear to be a minor, something which might have actually had a greater impact on ability to remove the individual, one might think, because of the sensitivity about removing minors. And what para 21 goes on to say was that that is directly material to the initial grant of discretionary leave, then ILR, leave to remain, and subsequent British citizenship. And one of the reasons why, in one sense, the argument was stronger, if you go back to paragraph 1 of the judgment of the upper tribunal, it is correct. The reason I said it would be more difficult to remove a minor is because as a minor, he got, the individual got leave essentially as an unaccompanied minor.
Until they were 17 and a half. That right?
That was the normal practice, I think, from memory. And so, putting it in context, there was more of an issue of causation, in the sense that this was someone whose falsity led to them getting discretionary leave to remain. Their discretionary leave to remain prevented their removal while they got indefinite leave to remain, albeit the indefinite leave to remain had nothing to do with the nationality.
But essentially, the reasoning that's summarised in paragraph 42 is a chain of causation, starting with the initial deception, and it's like a series of dominoes. Without the deception, X wouldn't have happened, and then Y wouldn't have happened, and then he wouldn't have been granted citizenship. But there doesn't seem to be any independent reasoning from this summary about the impact on good character of that deception. It doesn't seem to have been relied on.
Well, para 21 is perhaps obscure but it's saying it's directly material, obviously, to the British citizenship. But it's not clear.
Well, it's in the context of this chain of causation, isn't it? That's the sensible way of reading it.
Well, but you go back to on our reading of the letter, there is a similar chain of causation issue being relied upon by the Secretary of State.
Yes, but it's not the only issue being relied on one view of the letter.
Yeah. Oh,
right.
But that goes. Yeah.
I mean, I've got your points both about this decision letter and about the one in this case.
Yes, but the critical reasoning then of the upper tribunal, having reviewed among other things, the same policies, obviously, that were an issue in this case, one sees the reference to those at paragraph 43 to 45. Is that what needs to be in issue is something that was directly material and at para 62, 63.
Yes.
The point that was being made essentially was that the ILR decision was not dependent on age. It's fair to say, just put it in context, para 65 is where the court, where the upper tribunal looks at whether or not there was a suggestion that the impact of the false date of birth on the citizenship application.
Yes.
So in other words, that wasn't argued.
Well, it wasn't argued, that's correct, but that's in one sense the context. It goes back to why I was saying that the approach of the Home Office presenting officer is potentially so significant, because
But from the summary of the decision letter, there was no basis for running such an argument because it wasn't relied on in the decision letter.
well, it would have been potentially open. Well, in one sense, this may not matter, but my point is that on the words para 21 of the decision letter, it would have been open to the Home Office to say, look, we're saying the deception was directly material to British citizenship.
So Sleeman may be right on the facts that were presented to it, but it doesn't bind us in any event.
Doesn't. I'm not suggesting it binds. The primary reason why it's relevant at the moment is not because of what it says about the outcome. And in one sense, my high point in terms of the substantive outcome, were the court to be directly determining the issue, is the Home Office's policy. And the example B that I took you to, and I accept that's probably my high point, but it's an upper tribunal decision. It's clearly not binding anyway. So the reason why I'm drawing it to your attention is because if you think about what the issue was for the upper tribunal in my submission, and you have to then focus obviously on the approach of the first tier tribunal judge. First tier tribunal judge is being presented with a case which it is said is directly relevant. He's being presented properly by the appellant, who is presenting their reading of the refusal letter. So the Home Office has a significant opportunity to essentially say, well, we're distinguishing Sleeman because of the impact, in this case, on the grant of citizenship. Something which would have been difficult, we would say, because of example B, but that would have been potentially open. But the Home Office presenting officer doesn't do that.
Well, the Home Office presenting officer attempted to distinguish Sleeman, but without having read it, was an uphill struggle. But we're not here to penalise false advocacy. We're here to try and get to the right answer, aren't we?
Well, here we would submit to try and get to a just answer, and the point I'm making is it's not about penalising bad advocacy. It's that the Home Office had their opportunity to put their case. The appellant's case was very clear.
Which was that Sleeman was indistinguishable, and we put a ground of distinction to you so that you can fairly deal with it.
Exactly, and that is put to the Home Office. The immigration judge, in my submission, fairly gives the Home Office multiple opportunities to engage with Sleeman, gives them also an opportunity to take time, and in those circumstances, in my submission, it becomes very difficult to criticise the first tier tribunal judge when he ultimately says, well, I've looked at Sleeman. It seems to me that it supports the appellant's case, and nothing's been put forward to.
But knowing what we now know, which is that there is a distinction between the letter in Sleeman and the letter here, are you still saying we're bound by what happened in front of the FTT?
Yes, because the question ultimately, in one sense, was, of course, that. In any case, in one sense, there are always factual distinctions. The question is, were the distinctions material in circumstances where there was a dispute about the meaning of the letter? Because certainly on our reading of the letter, the point that's being made in para 63 doesn't arise on the facts of this case.
65.
65. Sorry.
Right.
Yes. Sorry, I was looking long distance, and my eyesight wasn't quite as good as it was. But and also, I probably need to clarify an answer I gave a moment ago, in the sense that I'm not. if the refusal letter here, well, if the Secretary of State's case is, that's a better way of putting it, that if the Secretary of State's case is that had I been aware, and remember this is effectively the approach of the FTT, and this aspect of the FTT's reasoning is not challenged. Had I been aware that, in fact, the grant of the falsity rather regarding citizenship was not relevant to the grant of ILR, because that's a starting point. It's quite an important starting point. But had I also been aware that that falsity was maintained on the application for citizenship, I would have then refused citizenship. Had that been the Secretary of State's clear case, and then that would have potentially provided a basis for distinguishing Sleeman, given paragraph 65. But it wasn't in my submission the Secretary of State's clear case, and instead what happens is that the Secretary of State is invited to explain what basis they're distinguishing Sleeman and don't come up with a proper basis for distinguishing it.
Yes, so the first-tier tribunal judge's decision is that he accepts the submissions made that Sleeman was indistinguishable.
Yes, on the facts.
On the facts.
Yes.
Now, what, as my lord's asking, what happens if he was wrong about that?
Well, in my submission, that one sense starts possibly from the wrong starting point, in the sense that potentially the question should be not was he wrong, but was he entitled to come to the conclusions he reached about.
I would rather if he was wrong, arguably wrong, because the upper tribunal judge only ordered a rehearing, arguably wrong, because he failed to consider other matters.
Well, I think he'd have to have been wrong because the upper tribunal detected an error of law.
Yes, he would have had to, wrong in his approach, not necessarily. So in other words, what you're saying is that the scope of the decision what is confined by, restricted to, the scope of the submissions made by the presenting officer. But surely what we're looking at is whether the upper tribunal was right to decide that the first-tier tribunal's approach decision was wrong.
What you're required to look at, in my submission, is whether the upper tribunal was entitled to conclude that there was an error of law by the first-tier tribunal judge.
Yes.
And that's why, in one sense, I was focusing on what the approach of whether the first-tier tribunal that approach was proper. I mean, it would be, because there was no oral evidence. In one sense, this court could say, well, actually, knowing what we do now, we would, as a matter of fact, distinguish. But that's obviously not the right issue. The issue isn't whether this court would distinguish Lehman. The question is whether the first-tier tribunal judge was entitled to adopt the approach he adopted. And in my submission, the point I'm making is he adopted, in my submission, one way of putting it is this: he adopted a fair approach to an issue of fact, or certainly an issue which a certain amount of deference has to be, for want of a better phrase, given to his judgment. And that question was, essentially was, And that issue was, what was the approach of the Secretary of State? Was the Secretary of State essentially making the error that was made in Schliemann, or was the reasoning of the Secretary of State different, essentially, to that in materially different, I should emphasise, materially different. And that depends essentially on your assessment of the reasoning of the Secretary of State.
In the letter.
Well,
How can what I don't understand is, how can the first-tier tribunal even begin to reach a conclusion on that question without analysing the decision letter, which it simply fails to do?
Well, they can begin to, in part, because, of course, by that stage, it's not simply the decision letter. The Secretary of State is represented. The Secretary of State is represented by someone who is in a position to clarify what the Secretary of State's position is.
Okay. So is that it on Schliemann?
That's it on Schliemann, yeah.
So you're now going to take us to the...
I should say that the Secretary of State obviously highlights two subsequent decisions of the upper tribunal, Matusha and Muslijaj. Horrible pronunciation, I'm sorry for that.
Can you just give us the reference?
Yes.
That might be easier.
That may be easier. Tab 23 and
Thank you.
tab 29. I think I would submit, certainly for these purposes, it's probably, I mean, I can come back to them in reply if it assists, but I'm not, I think, on reflection, going to take you to them unless you, because they both post-date, so there's no suggestion that the immigration judge wasn't entitled to sort of focus on Schliemann, effectively. So I'm not, in one sense, the fact the upper tribunal has reached different decisions on different facts, I'm not sure takes you very far.
I mean, the real issue is whether in paragraph 16 the FTT judge was entitled to say the facts are materially identical to Schliemann. Which was his reason for allowing the appeal.
Yes.
So are you submitting that these two later decisions of the upper tribunal aren't authority for any relevant proposition of law? Is that your submission?
Yes. I mean, all... If it assists, just to...
Well, I'd just like to know whether or not that is your submission, first of all.
Well, yes, they don't assist with any... Absolutely. No, that is my submission.
Thank you. Well, we'll wait and see how Ms. Smith relies on them.
Yeah.
Yes.
Obviously, the authority of this court that we rely upon is JK Democratic Republic of Congo, which is in the authorities bundle at tab 2, and the relevant passage starts at page 56 of the bundle. Actually, no, 49.
Yes.
And to put it in context, the upper tribunal has allowed an appeal in circumstances which perhaps seem quite similar to this case. You see that at para 3, where what was said was that the immigration judge didn't properly consider the reasons in the refusal letter, albeit not assisted by representation on the day.
This was a case in which the appellant gave evidence
Yes.
and effectively his account was believed by the FTC or the immigration judge.
Yes.
Right.
I think, from memory, that's right, yes.
Well, it says so in paragraph 2.
Yes. But the issues, just again, the court's note really, as much as anything, that were not considered, or which were said not to have been considered by the upper tribunal, were those set out at paragraph 4.
But paragraph 3, there was no dispute that if the appellant's account was to be believed, the judge was right to allow his asylum claim.
Yes.
So was the issue in that case a challenge to the judge's conclusion that he believed the appellant's account?
Yes, it was a challenge to the conclusion based on the failure when reaching conclusions about credibility to address matters raised in the refusal.
Exactly. So it was a challenge to a judge's finding of fact, saying you haven't considered matters that you should have considered, namely the matters set out in the letter when determining credibility.
Yes.
And the only reason I'm saying that is that's slightly different from our case.
But
Considerably different.
I'm not sure I'd completely accept that, partly because in one sense, when looking at the issue of materiality, which is what was in issue, I mean, ultimately, if we're correct, at least on Begum, it may matter whether, and this is where the Begum issue may come into play, but if we're correct on the approach in Begum, then it's ultimately up to the judge to make findings effectively as to what was material and what wasn't material. And that's a factual issue, we would argue.
Right.
Which is one of the ways that Begum, it goes back to the question I think that was put to me by my lady, Lady Justice Laing, which is the extent to which Begum might have been relevant. And one of the reasons why Begum might have been relevant is that or might be said to be relevant, is that if we're right about Begum, then the question of materiality is ultimately for the court to assess.
And are the sideline passages the passages that you rely on?
I think so, yes.
Right.
Yes. Yes. And they're page 56 onwards, and page 56 and 57, which is where
when the court is to, when there's reference being made to the points not pursued, it's the points not pursued in cross-examination. Right? Because if you look at the end of I'm just trying to understand what's being referred to. At the end of paragraph 25, it said, in this case, the presenting officer appears to have done a competent job in pursuing the points that she regarded as the ones which needed to be tested in cross-examination, and then rejecting the broad submission that was due to the judge to pursue and address individually the points which the presenting officer had not pursued. And I assume that's all directed to cross-examination or raised in evidence.
I mean, there clearly was an issue about cross-examination, but for what it's worth, there would have been the opportunity to make submissions as well, and if you go to para 34,
yes,
part of the argument for the Secretary of State, was that in submission, the presenting officer, it's sort of the last 7 lines of para 34, the presenting officer had expressly said, I'm relying on the refusal letter.
yes,
So it's...
Right, I see. But wasn't this a case where there were findings of facts, I believe you, and then the criticism was, well, fine if you're going to believe you, but you should have dealt with 11 points which were set out in a refusal letter, only 9 of which were then pursued in cross-examination. And they said, well, in those circumstances, the judge was entitled to make those findings. That's completely different from saying, actually, when you've said an authority is indistinguishable, it isn't.
Well, it's, I don't accept necessarily it's as straightforward as that, in the sense that as I say, materiality is arguably we would submit is despite Begum, is a factual issue ultimately for the tribunal. What was being said was look at the approach that was adopted in Schliemann in very similar circumstances because of the requirement for materiality to be directly material. The issues that the falsity relied upon here wasn't directly material, and in that circumstance, the question was the question is, which is what in our submission was being addressed in JK, was when looking at what was material, was the first-tier tribunal judge bound to go beyond essentially what was being argued orally, what was being said orally.
Right, thank you.
Now, I should say, and again, I'm not going to necessarily go into that in great detail, but obviously the Secretary of State relies on authority about new legal arguments, effectively, legal arguments that weren't raised below. That, in our submission, is not really what this case is about, which is one of the reasons why...
I don't think that's suggested. I think what's being suggested is that this case is a fortiori, but maybe I've misunderstood.
My lady, no, that's correct. Grateful.
Yeah, but the reason why I draw attention to that distinction is because, well, for several reasons, really. Firstly, if one thinks about the issue of or the jurisdiction of the upper tribunal, the upper tribunal's jurisdiction is to consider errors of law. Where you have a situation, and that which arises from time to time, where a first-tier tribunal judge makes an error of law effectively because one of the parties hasn't presented a relevant argument, in one sense, it doesn't change the fact that there's an error of law because they approach the matter in the wrong way. But they may be faultless, but they approach the matter in the wrong way. Here, in one sense, the focus is quite different. The focus has to be on the approach of the first-tier tribunal to what was clearly the central issue, and the central issue he focused on, which was the materiality of the undisputed falsity.
It was the central issue as the decision letter is analysed by the appellant, but it doesn't necessarily follow that analysis is correct.
Well, the point I was just making about materiality, that doesn't depend in one sense on the analysis of the letter, because here, I mean, in terms of the decision making, there are, and one can look at it as 2 or 3 stages. The first stage is, was there falsity? Not in dispute. Nobody's argued that was in dispute. Second question then is, was it material? Clearly in dispute on everybody's, as on everybody's sort of account, not least because the refusal letter itself recognises that the case that was being put by the appellant was not material. And then thirdly, one would have potentially gone on to another issue, which was, in any event, the exercise of discretion. But in this case, one never got to that exercise of discretion because of the way in which the case was resolved, because the discretion only came to be exercised if it was material. So the issue in the case was correctly identified by the first-tier tribunal judge. The question was, essentially, had he correctly considered all the circumstances or all the potential materiality, all the potential ways in which it was material. That was the point that was being raised against him, essentially. And that issue has to be considered in light, in our submission, the way it was put. The error of law is it's
So,
and that's why in our submission the case law. But the one way in which that case law does potentially assist is it recognises that even in relation to errors of law, effectively, or issues of law that weren't raised below, courts have to be, and I'm paraphrasing it, but hopefully properly, courts have to be very cautious about allowing people to have a second bite of the cherry, effectively, a second run at something that they were given a fair opportunity to address and failed to raise the matter. And that's consistent, we would submit, with the authority of just taking you to PK or whatever, I've forgotten the initials, but it's... JK, yes, sorry. Whatever.
Double check.
Sorry.
JK and the Democratic Republic.
Yes, JK. But I mean, that's the underlying theme. One has to be. One can expect parties to properly advance their case, and that really fundamentally is the point that we're making. Is that the first-tier tribunal judge was entitled to present this in terms of, in light of the way in which the case was presented to him.
Can I just ask you? There is an inquisitorial function in tribunals, and it's not unknown for many unrepresented appellants to turn up and not take points. I mean, I hope that no part of your submission is that the tribunal shouldn't do their best to assist them in identifying points that need to be addressed.
No, but firstly, this is obviously not a situation where there was an unrepresented party before the tribunal. The Secretary of State was represented. And also, I wouldn't accept, in one sense, the categorisation that I wouldn't accept. I don't think my lord was putting this to me. I wouldn't suggest that what happened in this case was essentially no assistance was being provided, because the first-tier tribunal judge, perfectly properly in my submission, said, "Look, this is what troubles me. Do you want an opportunity? Can you assist me? Do you want an opportunity to address me on it?"
If the Secretary of State hadn't been represented at all, would the first-tier tribunal have been obliged to consider the points taken in the decision letter, and not just the point that was focused on by the appellant?
What? I'm not sure, again, I would necessarily accept what might be the underlying premise of that question. The way in which, in my submission, if the Secretary of State had been unrepresented, the way in which the matter, and I'm going to assume, because that may help in one sense, that there wasn't any written engagement. You just had all that there was the Secretary of State's decision letter. The way in which that would have needed to be resolved, in my submission, in those circumstances, is that the first-tier tribunal judge would have heard from the appellant, would have heard the appellant's submissions about materiality. Would have needed, essentially, to assess whether the appellant's point about the decision letter was right, and that ultimately would have been primarily an issue for the first-tier tribunal, and then would have needed to, based on whatever they concluded about what was being said in the decision letter, reached a conclusion, and this is where begging potentially comes into play, whether or not they agreed with that about materiality based on the material before them, including, in particular, obviously the policy I've taken you to, the example B.
So you are I think you're accepting that if the Secretary of State had not been represented at all, the first-tier tribunal would have been obliged to consider the terms of the decision letter. I just want to be clear. I mean, are you accepting that or not?
Well, I suppose the point I'm making really is that had the first-tier tribunal said, the argument of the appellant is based on Sleeman, based on the Home Office policy, this case is indistinguishable from Sleeman. That would have been an adequate way of dealing with the matter, because it would have been engaging, it would have been explaining why the appeal was being allowed, and it would have been engaging.
So your submission is
with
that
the
if the Secretary of State had not been represented. I just want you to answer the question clearly. As I understand the way your answer is going, your submission is that the First-Tier Tribunal would not have been obliged to analyse the decision letter.
Yes, I mean,
Yes. Right. Well, that's fine. Just say yes. That's all I want to know. Thank you.
One thing my junior points out, though, is which I should make clear as well, is that just dealing with that point as well. Of course, and this is recognised in JK, is that there can be and it links into the point my Lord made about the proceedings potentially being not entirely adversarial. It would have been perfectly proper in my submission, potentially in those circumstances where there was a lack of representation, for the first-tier tribunal judge to say, actually, I am concerned that, as things stand, I am not sure I can see a basis for distinguishing Sleeman, but I'm going to adjourn it and give the Home Office one opportunity to attend.
All right.
I mean, Lady Justice Arden, as she then was in JK, in her concurring judgment, makes that sort of point.
So where have you got to in your submissions?
Well, I think I'm now at the point where I've submitted essentially why we would submit there is no basis for concluding that the first-tier tribunal judge erred in law. That leaves the Begum issue, essentially. Can I just before
Yes.
I do that, my learned juniors pointed out that, as I say, we've handed up the statement. I haven't had an opportunity
Yes.
because
I
only have a soft copy because it's been
Right.
emailed to me. It might. I don't know whether there's anything I need to say about
Okay.
the statement.
How long do you think your submissions on the Begum issue would take?
I would say hour to an hour and a half.
Okay. So what we'll do is we'll stop now,
Yeah.
and we'll start again. Probably it was 5 to 2.
Yeah. And the court wants me to address the court on Begum.
We're going to discuss it.
Okay.
So be prepared for either.
Okay, that's fair enough. I'm certainly
Or both.
Yes.
Either or both, which
Yes.
is the right way of describing it.
Yeah. As I say, certainly from our point of view, we would be keen to address it.
I
not least
understand that.
because-
I've got that.
Yeah.
We've got that point.
Yeah.
Thank you.
Court rise.
Hold on.